So today we're going to be talking about a subject that I know is near and dear to many of your hearts: marijuana. The question always comes up whether or not you can participate in the weed and still be in possession of firearms, or even own firearms to begin with. But we just had a case that came out of the Fifth Circuit Court of Appeals, where the court has effectively overturned a conviction for somebody who was convicted of being an unlawful user of marijuana and in possession of a firearm, and therefore was sentenced to 4.5 years in federal prison. All right, so the case is called U.S. v. Daniels. The fact pattern is kind of interesting in and of itself, and I suspect there's probably a little bit more to the fact pattern than the court is necessarily letting on. But effectively, Mr. Daniels had a couple of firearms with him, was driving in Mississippi, and was pulled over by 2 law enforcement officers. At least one of these law enforcement officers was a DEA agent. Now, the pretext for the car stop had to do with expired tags. Why a DEA agent was doing a ride-along, I guess, and pulling people over for expired car tags, that probably requires another video, right? But nonetheless, they pull Mr. Daniels over. Mr. Daniels readily admits that he is in possession of a couple of firearms, and the DEA agent can smell the presence of marijuana. So they arrest Mr. Daniels and they bring him into the station. I'm not entirely clear what station they brought him into, but they bring him into the station. Mr. Daniels freely admits that he usually smokes about 14 times a month. So about every other day he has a joint, I guess, of marijuana. They promptly arrest him for violation of the 1968 Gun Control Act, specifically Section 18 U.S.C. 922, stating that he is an prohibited individual because he is an unlawful user of marijuana. And he attempts, when he goes to trial, to claim that this is a violation of his Second Amendment rights. And the trial court says, "You're a pothead. I don't want to hear about that." So they prevent him from articulating that. He is convicted by the federal jury, and then he appeals this to the Fifth Circuit Court of Appeals, where Jerry Smith, the judge on the Fifth Circuit Court of Appeals, overturns his conviction. And his analysis that he goes through using Bruen is spot on. I mean, you know, I've complained a lot in the past of these jurists that are outcome determinative. They want to achieve a certain result, you know, typically an anti-gun result, and they just go through these ridiculous intellectual gymnastics in trying to achieve their objective. And what they come up with is a discredit to the entire judicial system. I don't believe that, you know, Judge Smith is, you know, a avid pot user. I mean, maybe, I don't know. But it's not as though he's looking for an actual outcome. He's going through a rational, empirical, objective analysis based on the standards that have been laid down in Bruen. Hey guys, I'm pausing this video for just a moment. I want to talk a little bit about a giveaway that U.S.C.CA is doing, and what they're giving away is unbelievably cool. You can read all about it in the description just below this video, and definitely click on the link. All right, let's get back to the video. Now, this is the same court that just recently came out with the case of U.S. v. Rahimi. This is the one where they said that the domestic violence, it does not create a prohibited status, okay? And that case is actually going to the Supreme Court. We'll see how that ultimately results. But in this case, the Bruen analysis is really brilliant. He said, the state argues, well, he's a criminal, therefore he falls outside the scope of protection of the Second Amendment. And the court really discredits that right off the bat. And they say, well, perhaps at the moment that he's intoxicated, he might be engaged in criminal activity, but criminal activity doesn't have sort of a herpes theory attached to it. Once you've done it, you're not a criminal for the rest of your life. Between bouts of smoking this contraband, he's not engaged in criminal conduct. Therefore, he is still entitled to Second Amendment protections. Then they move on to the Bruen analysis, and they go through it pretty clearly. And they say, look, one of the questions that we ask is whether or not at the time of the ratification in 1791, was there a societal problem that was currently in existence that Congress and the ratifiers chose not to encompass within the Second Amendment. If there is no pre-existing legislation that survived the ratification, then it's pretty clear that the ratifiers intended the Second Amendment to be a broader scope. So, the question then comes down, were there people using marijuana back in 1791? And the court says, well, there may have been. I mean, we have absolutely no evidence to suggest it, but there were clearly people that got intoxicated back in 1791. This has always been a pre-existing issue with humanity. Since time immemorial, people have become intoxicated. And yes, there were laws that prohibited people from bearing arms while they were intoxicated. And effectively what they said was these laws looked at intoxication and considered that the functional equivalent to mental impairment. So someone who is suffering from some sort of mental disease cannot be in possession of dangerous weapons. I mean, we sort of understand that a mentally ill person creates a danger to themselves and a danger to society if they have access to weapons. And when someone is physically intoxicated, they are roughly identical to that of someone who's mentally impaired. The difference, though, is that intoxication goes away. Once it's gone, you're no longer intoxicated, ergo, you're no longer mentally impaired. And a statute preventing anyone who gets intoxicated occasionally from being in possession of a dangerous weapon is essentially disarming sober people. Now, on top of everything else, it gets into a somewhat of an analysis of when does unlawful user actually accrue? Back in college, I smoked a joint. Haven't had marijuana since. That was 30 some odd years ago. Does that mean I am still an unlawful user since back way before, anything dealing with YouTube or anything else, I happen to smoke a joint? The answer would be obviously no. But then as we get closer in temporal reality, right? 5 minutes ago I smoked a joint. Okay, well, maybe I'm still an unlawful user. The court essentially says it's irrelevant to go through that level of analysis. If you're sober, you have Second Amendment rights. It's that simple. And as a result of that section of the penal code, of specifically of the U.S. code, is unconstitutional as applied to Mr. Daniels. Now, this is not a broad overturning of 18 U.S.C. 922. So understand that. This is simply being done as applied. It's controlling legal authority and can be used for subsequent cases. But at least for the time being, if you're within the Fifth Circuit and you want to own a gun and occasionally take care of your glaucoma, you can do it. All right. Now, I did reference Hunter Biden in this whole thing, and there has been some discussion that Bruen could theoretically help out Hunter Biden, even post plea deal falling apart. The issue with Hunter Biden is certainly going to be whether or not at the time that he was in possession of a firearm, he was an unlawful user of narcotics. Had this been, adjudicated in the Fifth Circuit Court of Appeals, this case would control, okay? However, the issue that may manifest in Hunter Biden is when he filled out the 4473 form and whether or not he said that he was not an unlawful user at the time that he was filling out that document. If he said he wasn't an unlawful user, then he arguably committed perjury. Of course, his defense to that would be, no, when I was in the process of filling out that 4473 form, I was stone cold sober. All right, I had no intention of ever smoking marijuana, crack, or whatever else, the form of narcotics that he uses. I was never going to do it again, so I was no longer an unlawful user. 15 minutes later, after I left the gun store, I had a relapse. What can I tell you? So I think a perjury claim is probably going to fail. But it is interesting, and what's good about this case is not just simply that, okay, well, great, you can smoke marijuana and still, own a gun. What's great about this case is the level of analysis that the circuit court is doing in using Bruen. And this is the type of case that we'll be using for other, as controlling legal authority or persuasive authority for other cases going forward. As always, if you have questions and you'd like to email me, certainly do so at stephen@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.